Inspector Tindall and another, and Chief Constable Thames and another.
Mr. Warnock.
May it please my ladies and my lord, I appear on behalf of the appellant in this matter, along with my learned friend, Ms. Ella Davies. My learned friends, Mr. Nicholas Bowen, Queen's Counsel, and Mr. David Leamer, appear for the respondents.
Thank you.
My lady, this is the first defendant's appeal, the Chief Constable's appeal, against the order of Master McCloud, made on the 28th of April 2020, in which she dismissed his application to strike out or give summary judgment on a claim made against it by Mrs. Malcolm Tindall, suing on her own behalf and on behalf of the estate of Mr. Malcolm Tindall. The case arises out of an accident on the A413 in Buckinghamshire on the 2nd of March 2014 at some time between 5:40 and 5:52 in the morning. A collision between a vehicle driven by the deceased, Mr. Tindall, and a vehicle driven by a Mr. Bird occurred when Mr. Bird lost control of his vehicle on black ice, and tragically both men died. The issue which arises is whether the defendant is arguably liable in the tort of negligence for that accident, on the basis that his officers attended an earlier accident at the same location, caused by the same black ice, and assisted the driver involved in that accident, a Mr. Kendall, but left the scene without having made the road safe. The appellant's submission is that on the facts alleged, his officers owed no duty of care to Mr. Tindall, and thus that the claim does not disclose a reasonable cause of action or a claim with a real prospect of success. My lady, the structure I propose to take is to go briefly to the facts in some more detail, then to the law concerning the duties owed by public authorities, with particular reference to the triumvirate Supreme Court cases that have looked at this matter in some detail recently. Very briefly look at Ansel and Mcdermott, a case which has some similarities on the facts to this one. Then the law concerning rescuers and what constitutes making matters worse in a way which gives rise to potential liability in tort. The law concerning dangers on the highway specifically, and then, although I will have probably covered most of the grounds of appeal, in doing that, very briefly make submissions on the grounds of appeal in light of those authorities. So if I might first invite the court to take up the appeal bundle and go to the particulars of claim at page 71 of the bundle. They begin at page 69, but I'm going to pick up the story at page 71. And one gets, on page 71, under the heading, the first accident, the following. At approximately 1 hour and 15 to 20 minutes earlier, that's Mr. Tindall's accident, another motorist, one Martin Kendall, was travelling southbound in the direction of High Wycombe in a black Volkswagen Passat, registration W492, along the A413. The temperature was -2. And when Mr. Kendall's car approached the junction, despite seeing the same black ice, he lost control of the car, the back end of which lost grip on the ice, causing his car to slide into a ditch, roll and come to rest. It said that he was in some pain, but not seriously injured, and was able to exit his vehicle. He inspected the iced area, realised this was the cause of the accident, and it represented an imminent danger to other road users. And it said that given the dangerous state of the road, Mr. Kendall, despite being in pain, actively tried to signal to a van by waving vigorously to the driver, the idea being to stop or at least to slow traffic down or avoid the risk of any further accident, particularly the possibility that another car could leave the road and hit him or his own car. He then called 101 and was therefore unable to keep up his attempts to slow or stop traffic, which it is said he would have persisted in due to his concern that another driver would slide on the same ice into either him or his car. He spoke to the first defendant's civilian call handler, David Wilkie, and gave the facts of the accident, that his back and chest were hurting, and that he had tried to flag down the van, but the van slowed but failed to stop. And during the emergency call, he told the call handler there was ice all over the road, and that was the reason he'd spun off. The call handler told him officers were on their way to the scene, and that they'd been warned about the ice and that the road was dark and fast. And the call handler also remarked if another car comes off, the police could have a big problem, a really big problem. During the 13 minutes that Mr. Kendall was on the phone to the emergency services, he was unable to continue in his attempts to stop the traffic. And it said that but for the contact with the first defendant's call handler and the subsequent engagement and attendance of the police, Mr. Kendall would, despite being in pain, have persisted in his attempts, along with any other drivers who might or would have stopped to slow the traffic to prevent any further accidents caused by the said patch of black ice. And then it said, as pleaded below, at or about the time Mr. Kendall finished talking to the call handler, police officers had arrived, taken control of the scene by placing and removing a single slow warning sign, and it's alleged, therefore, by positive acts, assumed responsibility for the scene and the dangerous state of the road caused by the black ice. And at or around the same time as the police arrived, the fire and ambulance service arrived, and Mr. Kendall was taken to hospital. In relation to the police response, paragraphs 29 to 40, it said the job was allocated. The relevant officers, PC Irwin and Flanagan, arrived at the scene at 5:03 a.m., which the police, in a van which the police protocol did not require to carry signage that the road traffic officers would use to slow down traffic and warn of upcoming hazards. PC Stamp arrived about 3 minutes later at 5:06 a.m. His car was not properly equipped as it was only carrying one police slow sign instead of the two required under protocols. All three officers understood they were being called to an incident where there was a hazard consisting of ice. PC Irwin placed one road sign in the northbound carriageway, i.e. Carl Bird's direction of travel, after ensuring that Martin Kendall was not seriously injured. PC Flanagan checked the road for debris and swept the road. All three officers were aware of the hazard on the ice, having been told by Mr. Kendall, and also as a result of a conversation between PC Stamp and one of the fire crew, who made a remark to the effect, I'm sure there'll be another one joining later, thus alerting PC Stamp to the fire crew and Kendall's concerns that the road was very dangerous. And as a result of these concerns and the presence of the ice, PC Stamp then made a telephone call to the first defendant's control centre to request a gritter, but it said he failed to make a sufficiently robust request or communicate to the call handler how urgent the request was. The three officers stayed on scene until 5:26 a.m. when they left and returned to Amersham Station. PC Irwin removed the police slow sign and they resumed their duties, i.e. they left the scene at 5:26 a.m, some 20 to 25 minutes prior to the fatal collisions. The three police officers, paragraph 39, believing there was no hazard and having failed to discover or inspect the sheet ice and the continuing threat to life that it posed, had decided the situation did not justify them staying. And at or around the same time, the fire crew also left the scene, happy that Mr. Kendall had been taken to hospital and believing it safe to leave his car where it had come to rest.
Mr. Warnock, sorry to interrupt you at this early stage. I think it's common ground that we look at the facts as pleaded and take them at their highest for the claimant.
Yes.
But is there, for illustration purposes only, a plan? Is there a police plan floating around which you've got and we haven't got?
I haven't got it, and I'm not sure if there is one.
Does it exist? I don't want.
There may well have been, because there was a long inquest in these proceedings with.
I'm sure we can survive without it, but can I just see if I understand the position correctly? Mr. Kendall was travelling southbound.
Yes.
So he travelled from north of the ice, hit the ice, went on, finished up south of the ice.
But on
That's
which
right.
side? But which side of the road? I mean, it's pleaded that he slid into the roadside ditch. What isn't clear is in which carriageway.
Yes, it may be when we look at his statement that might cast light on that, but I can't actually remember.
Well, I'm not sure it does.
We'll certainly try and find out for you.
Anyway, yeah, and could you at some point clarify and confirm that at any rate he ends up south of the ice,
Yes.
which means that, if I can put it in this way, Mr. Bird has to pass his car before he hits the ice because he's going northbound,
Yes. Yes.
which means that the fatal collision happens north of the ice.
Yes. Yes, I will. Can I come back to my lord on that, having double checked that?
But I think that's what the northbounds and southbounds mean.
Yes.
But I think by my lady's questions and my questions, you will see that we're not absolutely sure, and it seems a fairly fundamental question.
Yes. The way that the case is put on duty is paragraph 57 of the particulars of claim, or paragraphs 54 to 57. It said that the officers were called out pursuant to their public duty in connection with road safety as opposed to the investigation and suppression of crime. The policy considerations often cited for immunity have no application in this case, which it said concerns a series of positive acts amounting to interventions which made matters worse. It said the case does not concern pure omissions, nor is it a case where the damage has been caused by the criminal act of the third party. And it said whilst it's arguable that the first defendant was not under a duty of care to attend the accident at all, it is established law, see for instance capital counties in Hampshire, that once the police officers were on the scene of Mr. Kendall's accident, they owed a duty of care to ensure that their attendance did not make matters worse for either Mr. Kendall and or that limited class of motorists in potential danger from the black ice. Irrespective of any wider protective private law duty inherent in or arising from the public law duty, the duty not to make things worse is an established and self-standing obligation in the law of tort. And it said that the said police officers, having promptly attended, were in a position to and did take control of the accident scene, but their negligence in assuming control responsibility and then relinquishing it prevented Mr. Kendall and other interested members of the public exercising self-help and protective measures as pleaded above. And then below it, paragraph 58. In paragraph 58, it said either individually or in concert with each other, all three of the said officers and Mr. Wilkie, the call handler, by their conduct made matters worse in that their attendance and subsequent negligence led directly to Mr. Kendall and other drivers who would have come to his aid, ceasing his own attempts to warn other motorists by vigorous arm waving and gesticulation at the side of the road. In the short time that he attempted to warn incoming cars, he had been successful in slowing traffic to safe speeds. Matters were made far worse by the attendance of the police, as had Mr. Kendall known they were not planning to attend, he would have persisted and or summoned help from others, along with unknown drivers who have stopped in his endeavours to slow the traffic and warn motorists of the hazard ahead. Further, but for the attendance of the police, the fire service would in all probability have taken control and remained at the scene and ensured the safety of road users until the ice hazard was cleared. And then,
So, Mr. Warnock, just so that I can understand this, it's not being said that the actual road was in a worse condition than it was when they
No,
arrived.
it's not.
It's exactly as it was
it's exactly
when
what
they
it is.
arrived.
In fact, if anything, it's slightly better because it's been swept.
It's been swept, yes. So the making it worse, it hinges on Mr. Kendall or somebody else might have done something differently.
Yes. What the case seems to come down to is that by simply turning up to the first accident and assisting with the rescue of Mr. Kendall, the police came under a duty of care to prevent further accidents at the same location because albeit unknown to them, they had not attended. Had they not attended, Mr. Kendall or others would have attempted to warn drivers of the ice.
But that's turning up is not alleged to be negligence.
No, it's not.
So
And that's one of the points I'll be making in due course.
And that's why I think this is really a question for Mr. Bowen. I think we may need a bit of precision about what he means by assumed responsibility.
Yes. As I understand his case, it's because the police put out a sign which they then removed again. But again, I'll be submitting that is not an assumption of responsibility or a making of matters worse in accordance with the authorities.
But for present purposes, we have to assume that it was causative.
We have to assume for present purposes it was causative. Yes. And we have to assume for present purposes that despite the fact he was removed from the scene on a spinal board, Mr. Kendall would in fact have continued or made efforts to try and wave down traffic had the police not attended.
We're not concerned with paragraph 59, are we?
No, but it is worth having a look at because it sets out what the negligence of the police is actually alleged to have been, and it's all, your lordship will see, it's all omission.
But for present purposes, Mr. Byrne, is this right? If the claimant loses on 58, the case goes as a whole.
No. I mean, we're not.
But subject to an appeal to the Supreme Court, which would be.
Well, plainly we have the argument both factual, there's a factual attack and a legal attack on the meaning of making matters worse. That goes to the narrowness or otherwise of the test that comes from East Suffolk, develops through Stovin. That's our first point. We say there's a narrow, established, clear route through.
So that's East Suffolk.
That's our first.
East Suffolk capital counties, Stovin.
Yeah, they say you need a positive act, which adds to the danger, and what's more, there's then the OLL point about having to cause physical injury, which we say even Mr. Justice, as he then was made, didn't even follow in daily. So we say that's a bit of a nothing point. Mr. Warnock's big point is trying to narrow to the sort of vanishing gap the route that the other Lord Justice, Stuart-Smith, left open and is consistent with Stovin. So we say the major point is you look at these cases, you look at whether the claimant's position is whether they are in a worse position as when compared to what would have been the case had the police not turned up at all, had they done nothing. That's quite clear from, we say, East Suffolk, Stovin, and then capital and counties. And you can take it through. So you don't need that positive act. That's the first point. The second point is the submission that you made in OLL, the law, relating to stopping somebody else coming to the protection of somebody else. That's what we refer to as Tafaris 2, the second exception to the omissions principle recognised by both Lord Reid in Robinson and then again reiterated in Poole. So that's the second clear and easy route through. Remembering that this is not a preliminary issue, this is a strikeout. I don't want to hijack
No.
my learned friend's position.
But the reason for my question,
Yeah.
forgive me for
Yeah.
cutting you slightly short, is you're not asking us between you simply for a judgment on paragraph 58.
Well, no. Well, 58.
58 is making matters worse.
That's pure making matters worse. No, because of course we have a very significant section on control.
Okay.
Which is, I mean, I'll be quiet in a minute, I promise you. Which is the modern way of reanalyzing Gibson and all. Which I don't know whether you've had a chance to look at that, Gibson and Orr and A.J. Allen. And we obviously say that you have to look at, again, at Ansel. So everything has to be looked at again through the lens of Robinson. The narrowness or otherwise of the exceptions, which with the exception of assumption of responsibility in the context of the failure to remove cases, which I'm sure you're familiar with, DFX, YXA, all of the ones that are going through at the moment. And there's a leapfrog appeal in a case called Champion next week. That's all about Tafaris 1 in the context of the public authority being child protection. This case is the first one that's looking at particularly at Tafaris 2 and Tafaris 3. So that's failing to protect your act stopping somebody else, and what is required in terms of control. Whether it go Dorset Yacht is the classic one, physical protection or physical custody of somebody, and then you will have Mr. Warnock will take you to all of this, I'm sure, and then Lord Toulson in Michael, around about paragraph 99, where he talks about Couch in the Supreme Court of New Zealand, and exactly whether when you have the power to influence and control the risk, it's a really significant point, which cannot, we say, conceivably be dealt with on the basis of hypothetical facts, on the context of a case which is before you, whereas we understand it. The test is this fanciful, is it bound to fail? Assumption of responsibility I'm not abandoning, but I can see certain issues with AOR. I mean, I'm not going to be banging on about general reliance, but I may well be talking about the need for specific reliance, which is, of course, again, the whole debate in the child protection cases is whether or not there's passive reliance by children. Of this whole area, years ago described as a nightmare jungle by Lord Bram-Wilkinson, is still in a state of flux. Last thing I'm going to say, Lord Justice Coulson described it as one of the frontiers of the law of negligence at the moment, third-party liability. So I certainly would be moderately disappointed, well, unless, of course, we lost, if we simply look at making matters worse. But just one thing I should say, I'm also feeling a little grim. I'll do my best to stay upright. But I'm hoping that overnight, plainly, we will consider considerably what because Mr. Warnock indicated he'd be about 4 hours. So I was assuming that we were going to, maybe I have a little bit at the end, but I pretty much said no.
Okay,
or maybe would have said
better sit down now, Mr. Bowman.
Thank you very much.
Mr. Bowman, before, do it from sitting down, please. There's no need to stand. It isn't as simple as, well, 58 goes and that's it. 59 is a quite separate pleading.
Yes, because the way that there is, the problem is, of course, there is no first instance decision on the wider aspect, because we can see problems. We can obviously see problems because of the degree of retrenchment in the Supreme Court in terms of the way they seem to be moving. So it's there on the pleadings, but we don't have a full decision because she said, well, if necessary, I don't need to say much about that because I'm letting the case through on the other basis.
Right, I think in the light of that, I'd better just look briefly at 59.
Well, it's more than briefly.
Yes.
It is a separately pleaded case on facts.
Yes. And what I say, my lady, about paragraph 59 is if one looks at the allegations, failures to carry out any form of risk assessment, failure to take any sufficient steps to slow the traffic, in particular failures not to have the right equipment, putting out a sign and removing it, failure to prevent a further accident, alternatively failing to request the gritter, or not staying at the scene until the gritter has arrived, or failing to close the road, failing to request appropriate support from the fire service and other police officers. All of those allegations which lead on to it assume responsibility, control, and then relinquish it. These are all allegations of omissions. There are things that are said that the police should have done but didn't. And in fact, not only do they fail in accordance with the law as explained by the Supreme Court, but there's existing Court of Appeal authority in the case of Ansel and Mcdermott, which applies to them.
Could we have full copies of Tafaris and Steele? Because I don't think they're in our bundles.
No.
We don't have it. There are two articles. There's a 2014 article and then the fuller article that followed the decision in Michael. So you probably only need the later one.
I'm speaking for myself. I'm sure I've seen them both.
Yeah.
If you have copies, could we have them? Otherwise, we'll try and find them ourselves.
No, we can certainly dig them up.
Thank you.
Just on that point, just to help you all, the difference between the two is the first one.
Don't worry about the difference between two. Let's read them.
Okay. My ladies and lords, if I could just turn very briefly to the witness statement of Mr. Kendall at page 47 of the supplemental bundle. I think he answers one of the points my lord asked. Paragraph 7 on page 48 of the supplemental bundle. He said that as I approached the entrance to the Woodland Park care home and Mackbridge Cottage just beyond, you could see the water coming off the field, which appeared at first sight to be dry but was glistening in the moon. I quickly realised I was looking at something between 20 to 30 foot of sheet ice and immediately eased off the accelerator. I resisted braking, fearing that this would cause me to crash. Nevertheless, the back end of my car lost traction as it reached the sheet ice. The car slid sideways and I completely lost control, crossing to the other side of the road and then crashing into a roadside ditch before rolling once or twice with the car eventually coming to rest on its right side. He says, I remember being surprised in the aftermath that I was still in one piece, though I immediately felt pain in my back and also my chest, where I had been restrained by my seat belt. Looked around, saw smoke coming out from under the bonnet of the car, was afraid it was going to burst into flames, so I got out of the passenger's door, which was partly jammed, as far as I could. I clambered up to the road, looked down from where I'd come from, studied the sheet ice more closely. I realised it was obviously the cause of the accident. As I was stood at the side of the road, I saw a van approaching the same stretch where I had just crashed. I actively tried to signal to the driver by vigorously waving my arms around, despite being in pain, but he either did not see me from my position on the side of the road or decided not to stop, as it was still very dark and there would have been no visible sign of my car in the ditch from the road. I suppose that if the driver had seen me, he would have been surprised by my appearance at that time in the morning. As it happened, the van was driving past slowly and didn't appear to be affected by the ice. I noticed that it turned into the access road for Woodlands Park care home. As soon as the van passed by, I decided to ring the police. I could not decide whether to dial 999, and so decided for some reason to dial 101 instead. I explained to the controller the facts of the accident and that my back and chest were hurting, and that I had tried to flag the van down, but it had failed to stop. A few other vehicles passed by while I was on this call, but I didn't try and flag them down as I was engaged on the phone. Had I not called the police, I would have continued my attempts to stop the traffic due to the dangerous state of the road. My immediate concern was that another driver might slide off on the ice and crash into me or my car. I was easily able to walk though, and would assess the level of my pain at that time as having been 5 on a scale of 10. By the time I finished my conversation with the emergency services controller, the emergency services had begun to arrive. I spoke to one of the police who had arrived, and he walked with me back to my car and examined it. He conducted a negative breath test, then placed me in the care of the ambulance service, which had also arrived, along with the fire brigade. At this stage, I assumed the police were clearly in control of the scene, so thought no more about it, and was treated at the scene and then transported by ambulance to hospital. I do remember the ambulance driver telling me the ice was extremely dangerous and that the ambulance had slid on it when arriving at the scene. Then at paragraph 16 to 18, he says, I've been asked for the purpose of these proceedings what action I would have taken had the police not arrived at all. The first thing I should say is it was obvious to me, and should have been obvious to anyone attending and seeing the sheet ice, that another accident was very likely to occur. To be clear, if I had realised that no help was going to be forthcoming from the police, I would have done my very best to warn other motorists of the sheet ice, and in fact I tried to do precisely that when attempting to flag down the van described at paragraph 9 above and before dialing 101. My lords and lady, what is not alleged is the following. There is no allegation that Mr. Kendall was in fact doing anything to stop traffic when the police officers arrived at the scene. There is no allegation.
Because of the evidence that he was wasn't indicating while he was talking to the controller,
Yes.
that he was still talking to the controller when they
Yes.
arrived.
He was talking to the controller, and then the police arrived, and he was handed over to the ambulance personnel, and he went off with the ambulance personnel to hospital. There's also no allegation that anyone instructed Mr. Kendall not to wave down traffic. There is, in fact, no allegation that the police exercised their powers to prevent Mr. Kendall from doing anything. There is no allegation that Mr. Kendall was removed from the scene involuntarily or against his will. There's no allegation that the police made any promise to him about what they would do about the road. And there's no allegation that he told the police that he would stay if they weren't going to make the road safe. And there's no allegation that the police made the road itself more dangerous than it was when they arrived. They left it in the same state as they found it. As regards Mr. Tindall, whose accident is the subject of this claim, there is no allegation that Mr. Tindall was aware of the earlier police attendance at the site or in any way relied upon it. And as I said earlier in response to my lady's question, what the case comes down to is an allegation that simply by turning up to the accident involving Mr. Kendall and assisting with the rescue of Mr. Kendall, the police came under a duty of care to prevent further accidents at the same location because, albeit unknown to them, had they not attended, Mr. Kendall or others would have attempted to warn drivers of the ice. My lady, it's against that background of the facts that I turn to the second topic, which is public authority liability generally in the light of the three recent decisions of the Supreme Court. That's Michael, the Chief Constable of South Wales, Robinson, the Chief Constable of West Yorkshire, and N and Poole Borough Council. I propose to start first with Robinson, since it sets out the clearest exposition of the law, but if it helps the court, the core propositions I derive from the cases and rely upon are set out at paragraphs 8 and 9 of my skeleton at page 14 of the bundle. And an apology to Lord Reid here, because what's happened is, I'm afraid, the version of the skeleton, the appeal bundle, is a non-proofread version of the skeleton, which was actually filed. Lord Reid is, of course, spelled R-E-E-D, not R-E-I-D. So I do the courtesy of correcting that.
Thank you.
The two core propositions we submit are that paragraph 8, the position is that absent a specific statutory provision which creates a civil liability, such as one, interestingly, which is applicable in this case to the second defendant, the Highways Act, section 41, public authorities stand in the same position as other individuals with regard to the law of tort. If a private citizen would not have owed a duty of care in the tort of negligence, nor will the public authority. Conversely, if a private citizen would have owed a duty of care, then so will the authority. And that is so even if the public authority has public law powers or duties enabling it or requiring it to prevent the harm in question. And secondly, in private citizens, like private citizens, public authorities do not generally owe a duty of care to protect individuals from harm. By contrast, if the public authority by its actions itself creates a source of danger or causes harm to an individual, then it may be liable like any other person. And with those two propositions in mind, may I invite the court, first of all, to turn up the case of Robinson at tab 13 of the authorities bundle. I'm sorry, it's not tab 13, it's tab 12. It is tab 13. Sorry, it is tab 13. It's Robinson and Chief Constable of West Yorkshire Police, reported in the Appeal Cases volume 2018 at page 736. And the essential facts are that two police officers made a decision to arrest a suspected drug dealer in the street. It was a busy afternoon in the town centre. During the way they carried out the arrest, a struggle took place, which resulted in both the police officers and the suspect being knocked into the claimant, who was a relatively frail woman, aged 76, who suffered injuries as a result. And the judge found that the way that the police had conducted the arrest was negligent, both in relation to their planning of their decision to do it and the way they executed it, and held but held that the police were immune. And the Court of Appeal on Appeal also dismissed the appeal, holding that no duty of care was owed by the police. And the Supreme Court unanimously allowed that appeal, although there was a difference in reasoning between two of its members and the majority judgment being given by Lord Reid. The difference in reasoning is actually quite nuanced, not terribly relevant for the current appeal. So I propose to focus on what Lord Reid says. And at paragraphs 22 to 23 of the judgment, starting on page 448 of the bundle or page 744 of the internal report, we'll start firstly at paragraph 21. He set out the fact that the proposition that there is a Caparo test which applies to all claims in the law of negligence, and that in consequence the court will only impose a duty of care where it considers it fair, just and reasonable to do so on the particular facts, is mistaken. And his lordship then reviewed the history of how this test arose, the Caparo test famously being the test which said that liability depended on whether harm was foreseeable, there was a sufficient relationship of proximity, and then whether it was fair, just and reasonable to impose a duty. He gave the history of how Anne's and Merton Borough Council had introduced a two-stage test based on foreseeability of harm and then public policy considerations. He said at paragraph 23 how that led to a period where the court struggled to contain liability, then referred to Caparo at 24, noting that in the Caparo case, the Supreme Court, the House of Lords, emphasised that there was no single general principle to provide a practical test, and says just above letter E, it was ironic therefore that immediately following the passage in Lord Bridges' speech has been treated as laying down such a test, despite, as Lord Toulson JC remarked to Michael, the pains he took to make clear that's not what he intended. His lordship went on at paragraph 26 that applying the approach adopted in the Caparo case, there are many situations in which there has been clearly established, sorry, I should say what he said the correct approach was, and it's that paragraph 24, letter E, citation from Caparo, What emerges from the post-Anne's decisions is that in addition to the foreseeability of damage, necessary ingredients in any situation giving rise to a duty of care are that there should exist between the party owing the duty and the party to whom it is owed a relationship characterized by the law as one of proximity or neighbourhood, and that the situation should be one in which the court considers it fair, just and reasonable that the law should impose the other. But it is implicit in the passages referred to that the concepts of proximity and fairness embodied in these additional ingredients are not susceptible of any precise definition, as would be necessary to give them utility as practical tests, but amount in effect to little more than convenient labels to which the features of different specific situations, which on a detailed examination of all the circumstances, the law recognises pragmatically as giving rise to a duty of care of a given scope. And Lord Bridge immediately went on to adopt an incremental approach based on the use of established authorities to provide guidance as to how novel questions should be decided. I think the law has now moved in the direction of attaching greater significance to the more traditional categorisation of distinct and recognisable situations as guides to the existence, the scope and the limits of the varied duties of care which the law imposes. We must now, I think, recognise the wisdom of the words of Mr. Justice Brennan in the High Court of Australia, in Sutherland Shire Council in Hayman, where he said it is preferable, in my view, that the law should develop novel categories of negligence incrementally and by analogy with established categories. It was that approach, and not a supposed tripartite test, which Lord Bridge then proceeded to apply to the facts before him. And applying the approach adopted in the Caparo case, there are many situations in which it has been clearly established that a duty of care is or is not owed. For example, by motorists to other road users, by manufacturers to consumers, by employers to their employees, and by doctors to their patients. As Lord Brian Wilkinson explained in Barrett and Enfield, once the decision is taken that, say, company auditors, though liable to shareholders for negligent auditing, are not liable to those proposing to invest in the company, that decision will apply to all future cases of the same kind. Whether the existence or non-existence of a duty of care has been established, a consideration of justice and reasonableness forms part of the basis on which the law has arrived at the relevant principles. It is therefore unnecessary and inappropriate to reconsider whether the existence of the duty is fair, just and reasonable, subject to the possibility that this court may be invited to depart from an established line of authority, nor a fortiori can justice and reasonableness constitute a basis for discarding established principles and deciding each case according to what may be regarded as its broader merits. Such an approach would be a recipe for inconsistency and uncertainty. Paragraph 27, he said it was only in a novel type of case where established principles do not provide an answer that the courts need to go beyond those principles in order to decide whether a duty of care should be recognised. And following the Caparo case, the characteristic approach of the common law in such situations is to develop incrementally and by analogy with established authority. His Lordship then turned to the law concerning public authorities in general, and at paragraphs 31 onwards. I'll just dip in and out of a few of those. Paragraph 31, before focusing on the position of police in particular, it may be helpful to consider the position of public authorities in general, as this is an area of negligence which went through a period of confusion following the case of Anne's, as explained in paragraphs 22 to 23 above. That confusion has not yet entirely dissipated, as courts continue to cite authorities from that period without always appreciating the extent to which their reasoning has been superseded by the return to orthodoxy, achieved first in Stoven and Wise, and then more fully and clearly in Gorringe and Calderdale Metropolitan Borough Council in 2004. At common law, public authorities are generally subject to the same liabilities in tort as private individuals and bodies. See, for example, Entick and Carrington and Mersey Docks and Harbour Board and Gibbs. Dicey famously stated that every official, from the Prime Minister down to a constable or a collector of taxes, is under the same responsibility for every act done without legal justification as any other citizen. See the law of the Constitution. An important exception at common law is the Crown. That exception was addressed by the Crown Proceeding Acts. Accordingly, if conduct would be tortious if committed by a private person or body, it is generally equally tortious if committed by a public authority. See, for example, Dorset Yacht and Home Office, as explained in Gorringe's case. That general principle is subject to the possibility that the common law or statute may provide others, for example, by authorising the conduct in question. See Geddes and the proprietors of the Bann Reservoir. It follows that public authorities are generally under a duty of care to avoid causing actionable harm in situations where a duty of care would arise under ordinary principles of the law of negligence, unless the law provides otherwise. On the other hand, public authorities, like private individuals and bodies, are generally under no duty of care to prevent the occurrence of harm. As Lord Toulson stated in Michael's case, the common law does not generally impose liability for pure omissions. This omissions principle has been helpfully summarised by Tuffaris and Steele, as in the tort of negligence, a person A is not under a duty to take care to prevent harm occurring to person B through a source of danger not created by A, unless 1A has assumed a responsibility to protect B from that danger, 2A has done something which prevents another from protecting B from that danger, 3A has a special level of control over that source of danger, or 4A's status creates an obligation to protect B from that danger. As that summary makes clear, there are certain circumstances in which public authorities, like private individuals and bodies, can come under a duty of care to prevent the occurrence of harm. See, for example, Barrett and Enfield, and that's the case when the local authority took a child into care and therefore came under a local parentis duty. And Phelps and Hillingdon London Borough Council, as explained in Gorringe's case. That was the case of the educational psychologist.
But this principle, principle Roman numeral 1, just between G and H, has to be applied bearing in mind the East Suffolk Capital and Counties line of authority,
yes,
which is that in general you're not liable unless you make matters worse.
Yes. Yes. And as I'll come on to submit, making matters worse on the authorities involves a positive negligent intervention.
Yes, and when one talks about assuming responsibility, again, it has to be in that context.
Yes.
That a public authority whose conduct may be negligent, but who does not make matters worse, will generally not be held to owe a duty having assumed responsibility.
Yes. There needs to be something some special relationship.
Sure.
Usually.
But then you go down Heddyburn or wherever
yes,
it might be.
Yes. And indeed, His Lordship provided some clarification, particularly in the Enfield case, and what that looks like.
Thank you.
And just to pick up the point my Lord just made, it's particularly paragraph 36. That is the position, notwithstanding that a public authority may have statutory powers or duties enabling or requiring it to prevent the harm in question, which I think makes the point my Lord's just made. And a well-known illustration of that principle is the decision of the House of Lords in the East Suffolk Rivers Catchment Board in Kent case. But the position is different if on its true construction, the statutory power or duty is intended to give rise to a duty to individual members of the public, which is enforceable by means of a private right of action. If, however, the statute does not create a private right of action, then it would be, to say the least, unusual if the mere existence of the statutory duty or a fortiori, a statutory power, could generate a common law duty of care. And then a further point closely related to the last. is that public authorities, like private individuals and bodies, generally no duty of care towards individuals to prevent them from being harmed by the conduct of a third party. See Smith and Littlewoods and Mitchell of Glasgow City Council. But there are circumstances where such a duty may be owed, as to Farris and Steele indicated in the passage quoted above. They include circumstances where the public authority has created a danger of harm which would not otherwise have existed, or has assumed a responsibility for an individual's safety on which the individual has relied. The first type of case situation is illustrated by the Dorset Yacht case, and in relation to the police by the case of Attorney General and the Attorney General of the British Virgin Islands and Hartwell. The second type of illustration is illustrated in relation to the police by an informer versus a chief constable. And then paragraph 40, until the reasoning in the Anne's case was repudiated, it was not possible to justify a rejection of liability, where a prima facie duty of care arose at the first stage of the analysis from foreseeability of harm, on the basis that public authorities are not generally liable for failing to exercise their statutory powers or duties so as to confer the benefit of protection from harm. Instead, it was necessary to have recourse to public policy in order to justify the rejection of liability at that second stage. That was accordingly the approach adopted by the House of Lords and the Court of Appeal in a series of judgments, including Hill's case. The need to have recourse to public policy for that purpose has been superseded by the return to orthodoxy in Gorringe's case. Since that case, a public authority's non-liability for the consequences of an omission can generally be justified on the basis that the omissions principle is a general principle of the law of negligence, and the law of negligence generally applies to public authorities in the same way that it applies to private individuals and bodies.
All right, Mr. Warnock, so what are you extrapolating from all of this?
Well, if one takes, to take it down to its bare essentials, assume that Mr. Kendall had been out waving down traffic, and assume he successfully waved down another driver. Assume that driver gets out of his car, gets the red triangle out of his boot that modern cars have, puts it on the road while he helps Mr. Kendall, and assume that driver calls an ambulance for Mr. Kendall, and Mr. Kendall was off to hospital, having no longer standing at the road waving down traffic. No one could conceivably allege that that member of the public owed a duty of care in respect of a later accident when they leave the scene packing their triangle back in the boot and go off having seen Mr. Kendall off in the ambulance. The position is exactly the same in relation to the police, because what these authorities say is they are subject to the same principles as any other person before the law. And so if, in the situation I've just described, that Good Samaritan would not come under a liability, why should the police? They simply don't. They haven't done anything which in any relevant sense added or created a fresh danger.
That's it.
That's, in a nutshell, that's what my submission comes down to.
And I suppose the same would apply, would it, if Mr. Kendall, instead of calling the first responders, had simply waved the traffic down for a bit and then stopped at some point.
Yes, in those circumstances, he would be like the sign the police temporarily put on the road. If that amounts to an assumption of responsibility, then so does standing waving at the side of the road and then deciding to stop and go home. It is with respect nonsense, but that analogy helps, perhaps, I hope, explain why.
When we come to capital and counties, you
Yes.
might answer a question along the same lines, which is what would the position have been if the fire brigade had manually switched on the sprinklers, if when they'd arrived the sprinklers weren't working, and they'd switched on the sprinklers and then someone else come along, Officer Mitchell had come along and switched them off again.
Yes, I think
But
that's
that's
that
later in your
echoes of my
submissions.
Lord's case, OOL, OLL. I think.
Yeah.
Yes.
Yes. Well, I mean, you understand I have an interest as losing counsel in OLL.
But I am going to come on to capital counties and OLL. But before I leave Robinson, in terms of the police in particular, paragraphs 44 and 45, on page 751 of the report, 455 of the bundle. His Lordship said that in relation to the question whether and in what circumstances a private law duty of care might be owed by the police to particular individuals, Lord Toulson discussed in Michael's case the case of Hill, and in particular the speech of Lord Keith, with whom Lord Brandon of Britain, Lord Oliver and Lord Gough agreed. Since it is apparent from the judgments below in the present proceedings and from the submissions of this court that Lord Keith's reasoning continues to be misunderstood, it is necessary to consider it once more. For the purpose of the present case, the most important aspect of Lord Keith's speech in Hill is that, in the words of Lord Toulson, he recognised that the general law of tort applies as much to the police as to anyone else. What Lord Keith said was this: there is no question that a police officer, like anyone else, may be liable in tort to a person who is injured as a direct result of his acts or omissions. So he may be liable in damages for assault, unlawful arrest, wrongful imprisonment, and malicious prosecution, and also for negligence. The words "like anyone else" are important. They indicate that the police are subject to liability for causing personal injury in accordance with the general law of tort. That is, as one would expect, given the general position of public authorities as explained at paragraphs 32 to 33 above. And at paragraph 50, His Lordship said, on the other hand, as Lord Toulson noted in Michael's case, Lord Keith held that the general duty of the police to enforce the law did not carry with it a private law duty towards individual members of the public. In particular, police officers investigating a series of murders did not owe a duty to the murderer's potential future victims to take reasonable care to apprehend him. That was again in accordance with the general law of negligence. As explained earlier, the common law does not normally impose liability for omissions, or more particularly for a failure to prevent harm caused by the conduct of third parties. Public authorities are not, therefore, generally under a duty of care to provide a benefit to individuals through the performance of their public duties in the absence of special circumstances, such as an assumption of responsibility. This was recognised by Lord Toulson in Michael's case. As he explained, the refusal of the courts to impose a private law duty on the police to exercise reasonable care to safeguard victims or potential victims of crime, except in cases where there has been representation and reliance, does not involve giving special treatment to the police. The question is therefore not whether the police should have special immunity, but whether an exception should be made to the ordinary application of common law principles. And then finally in this judgment, at paragraph 69, the debate between the majority and particularly Lord Hughes, but also Lord Mance, was Lord Hughes and Lord Mance thought that there was actually a larger role for public policy in deciding cases involving public authorities or the police than the majority's judgment perhaps recognised. So it's quite a nuanced debate because they weren't disagreeing fundamentally with the principles being expressed, and indeed they agreed with the result in this case. But they felt that the majority were glossing over some of the public policy issues which do arise in cases involving the police. I think that's all I need to say about that. But Lord Reid sought to address those concerns. He says, I do not suggest the discussion of policy considerations in cases such as Hill, Brooks and Smith should be consigned to history, but it is important to understand that such discussions are not a routine aspect of deciding cases in the law of negligence, and are unnecessary when existing principles would provide a clear basis for the decision as in the present appeal. And I would not agree with Lord J. Hughes' statement that they are the ultimate reason why there is no duty of care towards victims, suspects, or witnesses imposed on police officers engaged in the investigation and prevention of crime. The absence of duty towards victims of crime, for example, does not depend merely on a policy devised by a recent generation of judges in relation to policing. It is based on the application of a general and long-established principle that the common law imposes no liability to protect persons against harm caused by third parties in the absence of a recognised exception, such as voluntary assumption of responsibility. At point 4 on the following page, page 463 or 759 of the report, His Lordship said the distinction between careless acts causing personal injury, for which the law generally imposes liability, and careless omissions to prevent acts by other agencies causing personal injury, for which the common law generally imposes no liability, is not a mere alternative to policy-based reasoning, but is inherent in the nature of the tort of negligence. For the same reason, although the distinction, like any other distinction, can be difficult to draw in borderline cases, it is of fundamental importance. The central point is that the law of negligence generally imposes duties not to cause harm to other people or their property. It does not generally impose duties to provide them with benefits, including the prevention of harm caused by other agencies. Duties to provide benefits are in general voluntarily undertaken rather than being imposed by the common law, and are typically within the domain of contract, promises and trusts rather than tort. It follows from that basic characteristic of the law of negligence that liability is generally imposed for causing harm rather than for failing to prevent harm caused by other people or by natural causes.
Can I just, I'm sorry to interrupt you again, can I just see if I understand this? Because if there were a duty in the present case, then the police would be concurrent tortfeasors, assuming someone else is liable. But what this is saying is you don't get to that stage if all you've done is not protected from. So one really wants to put questions of concurrent causation and things like that out of mind.
Yes.
The only question is the harm, is there an independent cause of harm? Because if there is, in general, there's not a duty to prevent it.
Yes.
Is that a correct understanding?
Yes, and I think what he comes on to cite from in the next paragraph, which I will take you to, is a citation from Lord Hoffman, which asks in general terms how do you identify if something's an omission or a commission. But that's absolutely right. If you haven't by your own, we're at the question here of duty in the first place, and if you haven't by your own positive act created or added to the danger, then you will not have a liability unless you fall within one of the other exceptions, such as assumption of responsibility. But what His Lordship said was, that this principle that you're not liable for harm, failing to prevent harm caused by other people or by natural causes, is also consistent with that characteristic that the exceptions to the general non-imposition of liability for omissions include situations where there has been a voluntary assumption of responsibility to prevent harm, situations which have sometimes been described as being close or akin to contract, situations where a person has assumed a status which carries with it a responsibility to prevent harm, such as being a parent or standing in loco parentis, and situations where the omission arises in the context of the defendants having acted so as to create or increase a risk of harm. And I think I hope this touches on my Lord's point. The argument that most cases can be equally analysed in terms of either an act or omission, sometimes illustrated by asking whether a road accident is caused by the negligent driver's act of driving or by his omission to apply the brakes or to keep a good lookout, does not reflect the true nature and purpose of the distinction as explained above. The argument was answered by Lord Hoffman in Stoughton and Wise. One must have regard to the purpose of the distinction as it is used in the law of negligence, which is to distinguish between regulating the way in which an activity may be conducted and imposing a duty to act upon a person who is not carrying on any relevant activity. To hold the defendant liable for an act rather than an omission, it is therefore necessary to be able to say, according to common sense principles of causation, that the damage was caused by something which the defendant did. If I am driving at 50 miles an hour and fail to apply the brakes, the motorist with whom I collide can plausibly say that the damage was caused by my driving into him at 50 miles an hour. And of course, we rely on that because what we say in relation to, for instance, putting out of the sign and then putting it away again before Mr. Tindall's even anywhere near the scene, in no plausible sense could that be said to have caused this accident.
Mr. Warnock, I'm sure in reviewing the authorities you will be coming to Michael.
Yes, I am going to come to Michael. The reason
and in particular paragraphs 99 and 100.
Yes.
Right, very well.
The reasons I've started with Robinson is because it seemed to me, perhaps, I may not be right about this, but it seemed to me it was because he's reviewed Michael, it seems a very clear exposition of what the law is, but I do intend to come to Michael, including those paragraphs. Turning to briefly to the Poole case, because it is the case which then looked at Robinson. It's at tab 14. It's reported in the second volume of the Weekly Law Reports of 2019 against Poole Borough Council. And this case was a claim against the Social Services Authority, and the allegation was that the claimant family had been subject to harassment by their neighbours. The local authority took lots of steps, but ineffectual steps, to try and assist them. It carried out assessments of the needs of the children. It made them, it put in place child protection plans. But ultimately, the allegation was that all of these were unsuccessful and that the authority had owed a duty to do more, culminating in necessary if removing the children from their family in order to protect them from their neighbours. And we see at paragraphs 4 and 5 of the judgment a sort of summary of what had been happening. Said that following the placement in this particular
I think
housing,
you can assume, Mr. Warnock, that we're reasonably familiar with the
Thank you.
facts. Yeah.
May I then go to paragraphs 26, first of all, where page 493 of the bundle, 1488 of the report.
Yes.
Lord Reid said, as it was explained in Robinson, public authorities other than the Crown were traditionally understood to be subject to the same general principles of the law of tort and common law as private individuals. He then referred to the same cases. That position might be altered by statute, by imposing duties whose breach gave rise to a statutory liability and tort, or by excluding liability for conduct which would otherwise be tortious at common law. And then he summarised, he referred to Dorset Yacht and Co. And at paragraph 28, he reiterated that, like private individuals, public authorities did not generally owe a duty of care to confer benefits on individuals, for example, by protecting them from harm. In this context, I'm intentionally drawing a distinction between causing harm, that's making things worse, and failing to confer a benefit, not making things better, rather than the more traditional distinction between acts and omissions, partly because the former language better conveys the rationale of the distinction drawn in the authorities, and partly because the distinction between acts and omissions seems to be found difficult to apply. As in the case of private individuals, however, a duty to protect from harm or to confer some other benefit might arise in particular circumstances, as, for example, where the public authority had created the source of danger or had assumed responsibility to protect the claimant from harm. See Dorset Yacht and Gorringe. His Lordship pointed out, and it's worth bearing this in mind when one looks at some of the authorities my learned friend refers to, paragraph 34, it took time for the significance of Stoven and Wise and Gorringe to be fully appreciated. They were not cited, for example, in Van Col and Chief Constable of Hertfordshire. Confusion also persisted concerning the effect of Caparo until clarification was provided in Michael and Robinson. The long shadow cast by Anne's and the misunderstanding of Caparo have to be borne in mind when considering the reasoning of decisions concerned with the liabilities of public authorities in negligence, which date from the intervening period. Although the decisions themselves are generally consistent with the principles explained in Gorringe and later cases and can be rationalised on that basis, their reasoning has in some cases and to varying degrees been superseded by those later developments. And I ask the court to bear that particularly in mind when my learned friend takes you to passages in Van Col, which looked at the case from a public policy perspective. In this case, Lord Reid and the Supreme Court unanimously rejected the notion that there had been an assumption of responsibility. And at paragraphs 80 to 82 on page 1505 or 5110 of the bundle.
Sorry, can you give that?
Page 5110 of the bundle, paragraph 80. As Lord Brian Wilkinson explained in relation to the educational cases in X and Bedfordshire, particularly the Dorset case, a public body which offers a service to the public often assumes a responsibility to those using the service. The assumption of responsibility is an undertaking that reasonable care will be taken, either express or more commonly implied, usually from the reasonable foreseeability of reliance on the existence of such care. Thus, whether operated or privately or under statutory powers, a hospital undertakes to exercise reasonable care in the medical treatment of its patients. Same is true, mutatis mutandis, of an education authority accepting pupils into its schools. In the present case, on the other hand, the council's investigating and monitoring the claimant's position did not involve the provision of a service to them on which they or their mother could be expected to rely. It may have been reasonably foreseeable that their mother would be anxious that the council should act so as to protect the family from their neighbours, in particular by rehousing them. But anxiety does not amount to reliance. Nor could it be said that the claimants and their mother had entrusted their safety to the council, or that the council had accepted that responsibility. Nor had the council taken the claimants into its care and thereby assumed responsibility for their welfare. The position is not therefore the same as in Barrett and Enfield. In short, the nature of the statutory functions relied on in the particulars of claim did not in itself entail that the council assumed or undertook a responsibility towards the claimant to perform those functions with reasonable care. And then, in the passage relevant to the issue of striking out, His Lordship said, "It is of course possible, even where no such assumption can be inferred from the nature of the function itself, that it can nevertheless be inferred from the manner in which the public authority has behaved towards the claimant in a particular case. Since such an inference depends on the facts of the individual case, there may well be cases in which the existence or absence of an assumption of responsibility cannot be determined on a strikeout application. Nevertheless, the particulars of claim must provide some basis for the leading of evidence at trial from which an assumption of responsibility could be inferred. In the present case, however, the particulars of claim do not provide a basis for leading evidence about any particular behaviour by the council towards the claimants or their mothers, besides the performance of its statutory functions from which an assumption of responsibility might be inferred. Reference is made to an email written in 2009 in which the council's antisocial behaviour coordinator wrote to Amy that we do as much as is in our power to fulfill our duty of care towards you and your family, and yet we can't seem to get it right as far as you're concerned. But the email does not appear to have been concerned with the Council's functions under the 1989 Act, and in any event, a duty of care cannot be brought into being solely by a statement that it exists. See O'Rourke and Camden Lower Borough Council. And of course, the Supreme Court struck the case out. My lady, I then turn to Michael, which is in the bundle at tab 12, reported in the Appeal Cases volume for 2015 at 1732. And in this case, the facts were that the victim made a 999 call to the police from her home because her former partner was threatening to kill her. The police call operator wrongly graded the call, wrongly graded the urgency of the call, with the result that the police did not intend in time before her partner had tragically committed the wicked act. And this claim was brought by her estate. And the claim was struck out at common law. And the paragraph, I should say, Lady Hale and Lord Kerr dissented, but Lord Tolson gave the speech of the majority, and it was a 7-person Supreme Court. And I just note in passing that, like this case, the police officers involved had not covered themselves in glory. In paragraph 16, Lord Tolson noted that the investigation by the Independent Police Complaints Commission led to a lengthy report which contained serious criticisms of both police forces for individual and organisational failures. At paragraphs His Lordship considered the various background of the cases involving police generally, and I'm not going to go through that. The court will be very familiar with the history from Hill onwards. But at paragraph 71, His Lordship considered the position in relation to emergency services more generally. And that's on page 1755, 408 of the bundle. Claims against other emergency services have been treated in a similar way to claims against the police, except in the case of the ambulance service, to which I refer below. In capital and counties and Hampshire County Council, the Court of Appeal considered claims and negligence against fire authorities arising out of 3 incidents in which the fire brigade responded to a 999 call. In the first case, the fire brigade was called to a fire office premises in Hampshire. The fire triggered the operation of a heat-activated sprinkler system, but on arrival, a fire brigade officer gave instructions for the sprinkler system to be shut down. This led to the fire rapidly spreading out of control and the premises were destroyed. If the sprinkler system had been left on and the fire brigade had otherwise acted as it did to combat the fire, the premises would not have been destroyed. In the second case, the fire brigade was called to the scene of some fires in wasteland near to the claimant's industrial premises in London. When the fire brigade arrived, the fires had already been extinguished. After checking that there was no evidence of any continuing danger, the fire brigade left. Later, a fire broke out at the claimant's premises. They sued the fire authority alleging negligence in failing properly to inspect the wasteland and failing to ensure that all fires and risks of further fires in the area had been eliminated before leaving. And in the third case, the fire brigade was called to a fire at a chapel in Yorkshire. The water hydrants near the premises either failed to work or the officers were unable for a long time to locate them, and so water had to be fetched from a dam half a mile away. It should have been possible to contain the fire, but as a result of the water shortage, the whole building was destroyed. Under the Fire Services Act 1947, fire authorities were under a statutory duty, among other things, to secure the services for their area of a fire brigade and equipment, such as necessary to meet efficiently all normal requirements, and to take all reasonable measures to ensure that an adequate supply of water was available for use in case of fire. The owners of the chapel sued the fire authority for negligence and breach of statutory duty. They allege there ought to have been a proper system of inspection to ensure that hydrants were in working order and that the fire crew were at fault in failing to locate some of the hydrants sooner. The Court of Appeal upheld decisions to allow the claims in the Hampshire case, but to dismiss the claims in the London and Yorkshire cases. The difference was that in the Hampshire case, the fire brigade aggravated the situation by causing the sprinkler system to be turned off, whereas in the other cases, the failure of the fire brigade made things no worse than they were. And then, in drawing that distinction, the court applied the reasoning of the House of Lords in Geddes and Ban, East Suffolk and Kent. Then, picking up at 79, my Lord George Stuart-Smith's forensic outing, OLL Unlimited and the Secretary of State for Transport. Mr. Justice May struck out claims against the Coast Guard for negligence in responding to a 999 call. The Coast Guard is a non-statutory public authority with responsibility for organising and coordinating search and rescue missions on the coast and at sea. The claims arose from a tragic incident in which a party of children and teachers, under the supervision of instructors from an adventure centre, got into difficulties on a canoeing trip. The Coast Guard was alerted, but several hours passed before all the members of the party were rescued. Some of the children died and others suffered severe hypothermia. It was alleged that the Coast Guard was negligent in that it was slow to launch a search and rescue operation and misdirected a lifeboat and a helicopter about where they should search. In striking out the claims, the judge applied the reasoning in capital and counties in Hampshire. He rejected the argument that the misdirection of searchers was analogous to the fire brigade turning off the sprinkler system in the Hampshire case, because it did not positively increase the danger to the canoeists. It was similar to a fire brigade sending one of its fire engines to the wrong address. In the Van Collin Smith cases, Lord Bingham reserved his opinion about the correctness of capital and counties and disapproved OLL from the Secretary of State. But he was alone in criticising them, and he did so in the context of formulating his liability principle, which the other members of the House of Lords rejected. And then at paragraph 97, page 413 of the bundle, did the police owe a duty of care to Miss Michael on receiving her 999 call? 97, English law does not, as a general rule, impose liability on a defendant for injury or damage to the person or property of a claimant caused by the conduct of a third party, Smith and Littlewoods. The fundamental reason, as Lord Gough in that case explained, is that the common law does not generally impose liability for pure omissions. It is one thing to require a person who embarks in action which may harm others to exercise care. It is another matter to hold a person liable in damage, failing to prevent harm caused by someone else. The rule is not absolute. Apart from statutory exceptions, there are two well-recognised types of situation in which the common law may impose liability for a careless omission. The first is where D was in a position of control over T and should have foreseen the likelihood of T causing damage to somebody in close proximity if D failed to take reasonable care in the exercise of that control. The Dorset Yacht case is the classic example, and in that case, Lord Diplock set close limits to the scope of the liability. As Tipping J explained in Couch and Attorney General, this type of case requires careful analysis of two special relationships: the relationship between D and T, and the relationship between D and C. I would not wish to comment on Tipping J's formulation of the criteria for establishing the necessary special relationship between D and C without further argument. It is unnecessary to do so in this case, since Ms. Michael's murderer was not under the control of the police. and therefore there is no question of liability under this exception. The second general exception applies where D assumes a positive responsibility to safeguard C under the Headley-Byrne principle as explained in Spring and Guardian Assurance. It is not a new principle. It embraces the relationships in which a duty to take positive action typically arise: contract, fiduciary relationships, employer and employee, school and pupil, health professional and patient. The list is not exhaustive. This principle is the basis for the claimant's main submission, to which I will come. There has sometimes been a tendency for courts to use the expression assumption of responsibility, when in truth the responsibility is being imposed by the court rather than assumed by D. It should not be expanded artificially. These general principles have been worked out for the most part in cases involving private litigants, but they are equally applicable where D is a public body. Mitchell and Glasgow City Council is a good example. The victim and T were secure tenants of D and were next door neighbours. On a number of occasions, T directed abuse and threats to kill at the victim, which he reported to D. D summoned T to a meeting and threatened him with eviction without informing the victim. Soon afterwards, T attacked the victim, causing fatal injuries. The victim's widow and daughter sued D, alleging negligence in failing to warn him of the meeting with T. The House of Lords held that D was not under a duty to do so, applying the principle in Smith and Littlewood. It rejected the pursuer's arguments that D's relationships with its tenant, T, was analogous to the relationship of D and T in the Dorset yacht case, or that D assumed a responsibility to protect the victim from T. Mere foreseeability was not enough. It is true that the categories of negligence are never closed, see Heaven and Pender, and it would be open to the court to create a new exception to the general rule about omissions. The development of the law of negligence has been by an incremental process rather than giant steps. The established method of the court involves examining the decided cases to see how far the law has gone and where it has refrained from going. From that analysis, it looks to see whether there is an argument by analogy for extending liability to a new situation, or whether an earlier limitation is no longer logically or socially justifiable. In doing so, it pays regard to the need for overall coherence. Often there will be a mixture of policy considerations to take into account. My lady, with reference to paragraphs 99 to 100, it's helpful to look back at his lordship's summary of the two cases. And at paragraph 39 on page 402 of the bundle, 1749, Lord Keefe, he's here talking about the Hill case, referred to the decision of the House of Lords in Dorset Yacht and the Home Office, where Lord Diplock said that the development of the law of negligence proceeds by first identifying the relevant characteristics of the conduct and relationship between the parties involved in the particular case, and the kinds of conduct and relationships which have been held in previous decisions to give rise to a duty of care. In that case, it was held that an action in negligence could lie against prison officers who negligently allowed young offenders camping on an island under the prison officer's supervision to escape from the island by stealing the plaintiff's yacht. The reason for imposing liability was that the prison officers were responsible for exercising proper control over the wrongdoers who were in their charge, and there was sufficient proximity between the prison officers and the owners of the yachts in the close vicinity of the camp, because the use of their property as a means of escape was the very thing which the prison officers ought to have foreseen. By bringing the young offenders onto the island and leaving them unsupervised, the prison officers created a danger for the owners of the yachts which would not otherwise have existed. In contrast, Lord Diplock said that the courts would be exceeding their function in developing the common law to meet changing conditions if they were to recognise a duty of care to prevent criminals escaping from custody owed to a wider category of members of the public than those whose property was exposed to, quotes, an exceptional added risk by the adoption of a custodial system for young offenders, which increased the likelihood of their escape unless due care was taken.
Mr. Warnock, what is going to be said, and I'm not asking you to address it now, is this isn't a wide category of the public. This is a specific category of the public, i.e. those who will be driving along the road and hit this black area of ice.
Yes, I think that is what's said.
Well, it
But
is
the answer to it is now we'll be taking the court to some of the cases involving dangers on the highway, is that that is not sufficient because any member of the public could drive down the road. And the Supreme Court has looked at, well, it was the House of Lords has looked at that in Gorringe, but also this court has looked at it in a case called Sandhar. So I promise, come back to those cases. The other feature, of course, about the Dorset Yacht case, although it's put as a control case, well, there are two features to that. The first is it was clearly a control case because the Borstal boys were in the custody of the prison officers. Secondly, interestingly, the other way of analysing the case, which is referred to here, paragraph 39, is that it is in truth a creation of danger case because the danger arose because the Borstal boys were brought onto a small island and left unsupervised in circumstances where that obviously posed a risk to the owners of the yachts, whose boats provided the only means of escape. The other case his lordship referred to in that discussion about control was the Smith and Ure ones, and I think it suffices for my purposes to take you to the summary of that case which Lord Tolson gave at paragraph 88, it's on page 412, 1759 of the report. His lordship said, in New Zealand, the highest authority is the decision of the Supreme Court and Couch and Attorney General. Victims and relatives of victims injured or killed in a robbery claim damages and negligence for the alleged failure of the probation service to exercise reasonable care in the supervision of the offender, who was on licence after release from a prison sentence for aggravated robbery. The victims were employed at a club where the attacker had been allowed by the probation service to obtain work experience without the knowledge of the employer and his fellow employees about his background. The Supreme Court allowed an appeal by the claimant from the decision of the Court of Appeal that the claim should be struck out. This decision was unanimous, but there were differences as to the criteria for establishing a duty of care. The reasoning of the majority was given by Tipping J. He took as a starting point the well-known observation of Dixon J. and Smith and Lures that it is exceptional to find a duty in law to control another's actions to prevent harm to strangers, but that special relations may be the source of a duty of this nature. Tipping J. noted that the special relations to which Dixon J. referred were between the defendant and the wrongdoer, but there had additionally to be a special relationship between the defendant and the claimant. Special in the sense that there was sufficient proximity between the parties to make it fair, just and reasonable, subject to matters of policy, to impose the duty of care in issue. Tipping concluded that the power of the probation board over the wrongdoer's employment was arguably sufficient to establish the necessary relationship between the defendant and the wrongdoer, by analogy with the Dorset Yacht case. As to the relationship between the defendant and the claimant, the necessary proximity criterion would be established if she could show, as was arguable on the facts, that she as an individual or a member of an identifiable and sufficiently delineated class was the subject of a distinct and special risk of suffering harm. The necessary risk must be distinct in the sense of being clearly apparent, and it must be special in the sense that the plaintiff's individual circumstances or membership of the necessary class rendered her particularly vulnerable. If the requisite proximity was established, Tipping J said it would be necessary to address finally the question of policy, but that should be done when all the facts have been examined. And 2 points are apparent from that very accurate summary of the case. Firstly, again, one has a position where the attacker is under the control of the defendant because he's subject to probation, and therefore the probation officers have the right to determine where he can and can't work. Secondly, having that power, they introduced him or allowed him into an environment where the very thing that he was under probation for in the first place was likely to pose a risk to those with whom he was placed. Returning to this case, at paragraph to the judgment more generally, at paragraph 1112, Lord Tolson said, in some areas, such as healthcare and education, public authorities provide services which involve relationships with individual members of the public, giving rise to a recognised duty of care, no different from that which would be owed by any other entity providing the same service. A hospital and its medical staff owe the same duty to a patient, whether they are operating under the National Health Service or in the private sector. A school and its teaching staff owe the same duty to a pupil, whether it is a state-maintained school or a private school. Educational psychology is a professional service linked to education. An organisation which provides an educational psychology service and its educational staff owe the same duty to a pupil whether they are operating in the public or the private sector. Besides the provision of such services, which are not peculiarly governmental in their nature, it is a feature of our government, our system of government, that many areas of life are subject to forms of state-controlled licensing, regulation, inspection, intervention and assistance aimed at protecting the general public from physical or economic harm caused by the activities of other members of society or sometimes from natural disasters. Licensing of firearms, regulation of financial services, inspections of restaurants, factories and children's nurseries, and enforcement of building regulations are random examples. To compile a comprehensive list would be virtually impossible, because the system designed to protect the public from harm of one kind or another are so extensive. It does not follow from the setting up of a protective system for public resources that if it fails to achieve its purpose through organisational defects or fault on the part of an individual, the public at large should bear the additional burden of compensating a victim for harm caused by the action of a third party for whose behaviour the state is not responsible. To impose such a burden would be contrary to the ordinary principles of common law. The refusal of the courts to impose a private law duty on the police to exercise reasonable care to safeguard victims or potential victims of crime, except in cases where there has been a representation and reliance, does not involve giving special treatment to the police. It is consistent with the way in which the common law has been applied to other authorities vested with powers or duties as a matter of public law for the protection of the public. Examples at the highest level include Yoon Kun-yu and the Attorney General of Hong Kong, Davies and Radcliffe, no duty of care owed by financial regulators towards investigators, Murphy and Brentwood District Council, no duty of care owed to the owner of a house with defective foundations by the local authority which had passed the plans, Stoven and Wise and Gorringe and Calderdale Metropolitan Borough Council, no duty of care owed by a highway authority to take action to prevent accidents from known hazards. The question is therefore not whether the police should have a special immunity, but whether an exception should be made to the ordinary application of common law principles, which would cover the facts of the present case. Of course, the court held by a majority that there was no such exception. Just finally, before I leave this judgment, I'll just deal briefly with how they address the assumption of responsibility issue at paragraph 138, page 1769, page 422 of the bundle. Should the police issue 3, should the police be held to have assumed responsibility to take reasonable care for Ms. Michael's safety?
I'm very sorry, I missed where you
It's
were.
page 422 of the bundle, page 1769 of the report, paragraph 138.
Thank you.
Mr. Bowen submitted that what was said by the Gwent call handler who received Ms. Michael's 999 call was arguably sufficient to give rise to an assumption of responsibility on the Headley-Byrne principle as amplified in Spring and Guardian. I agree with the Court of Appeal that the argument is not tenable. The only assurance which the call handler gave to Ms. Michael was that she would pass on the call to the South Wales Police. She gave no promise how quickly they would respond. She told Miss Michael they would want to call her back and asked her to keep her phone free, but this did not amount to advising or instructing her to remain in her house, as was suggested. Miss Michael's call was made on her mobile phone, nor did the call handler's inquiry whether Miss Michael could lock the house amount to advising or instructing her to remain there. The case is very different from Kent and Griffiths, where the call handler gave misleading assurances that an ambulance would be arriving shortly.
Could you, I was listening, but I'm just still not on the right page. Which paragraph?
I'm so sorry. It's paragraph 138, 138.
Thank you. I have it. Thank you so much.
My lady, that's all I propose to say about the 3 Supreme Court cases of which have recently examined this issue. May I turn briefly to Ansel and Mcdermott, which is an older Court of Appeal decision, at tab 4 of the bundle. And it's reported in the Road Traffic Reports 1993 at page 235. And the facts were set out in the head note. Aluminium tubing fell on a road from a bulk carrier that was being driven by an employee of the 4th defendant. First defendant driving his car along that road failed to see the obstruction, ran over it, ruptured his fuel tank and left a trail of diesel fuel on the road. Minutes later, police officers from the 2nd defendant's force noticed the fuel on the road and followed the trail to the first defendant's stationary car. Those police officers notified police officers of the 3rd defendant's force of the hazard on the road, but did not themselves return to the scene. Shortly after, a police officer from the 3rd defendant's force drove past the spillage, noted diesel fuel on the road, reported the matter to the local highway authority, and continued on his way. Plaintiff's wife, driving alongside the road, struck the trail of fuel that caused her to skid, to go out of control, and collide with a lorry, and she died as a result of the injuries she sustained in the collision. And the 1st and 2nd plaintiff's passengers in the car were injured. Additional to their claims against the 1st and 4th defendants, the plaintiffs claimed against the 2nd and 3rd defendants, the chief constables of the 2 police forces, for breaches of duty and negligence of their officers. The judge, Mr. Justice Garland, had refused to strike them out. The Court of Appeal disagreed and allowed the chief constable's appeals, holding it was exceptional to find in the law a duty of care to control another's actions to prevent harm to strangers, and where it was found, it arose from a special relationship between the parties, and then more policy issues which would not generally prevail now. So I should say this case was clearly decided at a time when policy was still regarded as an important matter, but the case was decided on 2 bases, I submit. Firstly, conventional common law principle concerning omissions, which is the passage I've just read out from the holding, although secondly, the court would have struck it out on policy grounds as well. In terms of what was said in the case, at page 238 of the report, page 148 of the bundle, bottom of the page, reference was made to Hill and Chief Constable, the Yorkshire Ripper case. Lord Keith of Kinkle said, the question of law which is opened up by the case is whether the individual members of the police force in the course of carrying out their functions of controlling and keeping down the incidence of crime owe a duty of care to individual members of the public who may suffer injury to person or property through the activities of criminals, such as to result in liability and damages on the ground of negligence to anyone who suffers injury by reason of that duty. And he then set out the various passages of law concerning omissions and commissions. And he reviewed that case in full, and then he, over the page at 240, sorry, I should say we're in the judgment of Lord Justice Belden, referred to Alexandra, Chief Constable of Merseyside. This is at letter B on page 240, where the police responded to a burglar alarm that was directly connected to them, so equivalent to a 999 call, but was said to have negligently failed to secure the premises. And counsel accepted, or Mr. Ashworth accepted that in similar circumstances, if a member of the public driving upon the highway would not owe a duty of care to other users of the highway to guard them against perils created by others. Sorry, I've made that very confusing. At letter A on page 240, he said, not unnaturally, Mr. Ashworth, for the plaintiff, stressed that Lord Keith of Kinkle had been careful to confine the question of law opened up to whether members of the police force owed a duty to members of the public in the course of carrying out their functions of controlling and keeping down the incidence of crime. Alexandro and Chief Constable of Merseyside, on which the second and third defendants also relied, was likewise a case of failure to carry out proper investigations, which would have prevented a burglary after the burglars had set off the burglar alarm. Mr. Ashworth accepted that in similar circumstances a member of the public driving upon the highway would not owe a duty of care to other users of the highway to guard them against the perils created by others. And in the passage of the judgment of Lord Diplock and Dorset Yacht, quoted by Lord Keith in Hill's case, Lord Diplock had said, the branch of English law which deals with civil wrongs abounds with instances of acts, and more particularly of omissions, which give rise to no legal liability in the doer or omitter for loss or damage sustained by others as a consequence of the act or omission, however reasonably or probably that cause, loss or damage might have been anticipated. The very parable of the Good Samaritan in Luke 10, which was evoked by Lord Atkin and Donoghue and Stevenson, illustrates in the conduct of the priest and of the Levite who passed by on the other side an omission which was likely to have as its reasonable and probable consequence damage to the health of the victim of the thieves, but for which the priest and Levite would have incurred no civil liability in English law. Examples could be multiplied. Consequently, Mr. Ashworth founded his argument for a duty of care on the duty of police constables generally to guard the public from injury and from damage to loss of property. He submitted that this court in Haynes and Harwood had confirmed the existence of such a duty. In that case, the plaintiff, a police constable, claimed damages from the defendant for injuries he had sustained in attempting to stop the defendant's horses, which had bolted after being left unattended by the defendant's servant. The question of the police officer's duty arose only because the defendant had contended the plaintiff had voluntarily assumed the risk of injury, in that case he did. Malcolm rejected that, saying, in that case, in my opinion, the police constable was not in true sense a volunteer. It is true he was under no positive legal duty to run out into the street at the risk of his life to stop two galloping horses, and I quite accept that nobody would have thought of reprimanding him had he done nothing. It is also true that the primary duty of the police is the prevention of crime and the arrest of criminals. That is only part of the duties of the police in London. There is a general duty to protect the life and property of the inhabitants, a discretionary duty to direct traffic, to help the blind and infirm people cross the road, and to direct people who lost my way. And then at page 2153, bottom of page, letter L, I approach the question of the existence of a duty of care in the present case with these considerations in mind, and that's the questions of the parole. Firstly, as Lord Keith pointed out, in Yuen Kun Yeung, Attorney General of Hong Kong, there was clearly a special relationship between the prison officers and the owners of the yachts, so close and direct that a duty to take reasonable care to prevent damage to the yachts arose. But as his citation at page 193 from the judgment of Dixon and Smith and Gers shows, it is exceptional to find in the law a duty to control another's actions to prevent harm to strangers, and where they are found, they arise from special relationships. When it is contended that such special relationships arises out of the duties carried out in the performance of a public office, the court must have regard to the purpose and scope of the public duties, whether they are intended to benefit a particular section of the public, e.g. investors or depositors, and whether such persons could reasonably place reliance in the fulfilment of the duties. And then the second ground he gave is more of a policy ground, which I accept would not be relevant now post Robinson. Secondly, such a duty of care would impose upon the police force potential liability of almost unlimited scope. Sir John McGaw agreed that the appeal should be allowed, and he agreed with the reasons given by Beldam LJ. He referred to Hill and the fact that Hill was struck out. And he concluded his judgment on page 245 in the final paragraph as saying that that being the position regarding criminal investigation by the police, where the duty owed to the general public rests exclusively on the police, I can see no valid reason for holding that a more extensive duty exists, a duty owed to individual members of the public in respect of a sphere of public duty where the primary duty, maintaining the safety of the highways, rests on public authorities other than the police.
So, Mr. Warnock, are you saying, because it is clear when one looks at page 239 at letter G, that ANS was one of the authorities relied upon?
Yes, it was.
So therefore one needs a degree of caution in approaching this case?
Absolutely. As Lord Reid said, one has to approach cases from this era with a degree of caution about their reasoning. As he also said, they're mostly all rightly decided, but one has to look carefully at the reasons for the decision. But what I say about this was, in this case, actually the correct reasoning was applied because the court analysed it in terms of it being a case of omission and looked at the law on that basis, on the basis that starting point was that there is generally no liabilities for failure to protect from harm. And that was the first reason that Beldam LJ held that the case should be struck out in that passage on page 24, begins at the bottom of page 243 and runs to 244.
But public policy can still have a relevance if what the court is being asked to do is to go beyond the established categories of.
Yes.
So if we were to be satisfied that, to put it simply, the present case is an Ansel and Mcdermott case,
Yes.
Leave aside whether we're bound and so on, but if we were being asked then to take the step and say, well, actually, liability applies even though there's no causing of damage, then public policy would come in and we would have to start doing a fair, just and reasonable inquiry.
You would. I mean, what Robinson allowed was that if the court decided actually the law needs a complete rethink in an area which is decided by established principles, it is always open to the courts to do that, although I'd fully submit with great respect to this court, that would be a matter for the Supreme Court, particularly in the light of the judgments they've recently given in this area. The other area where policy may be relevant, but it's not this case, because I say this case is covered by the established law, is if there is a genuinely novel case which goes beyond established principles. One looks at the established principles to guide one to an answer, but public policy may come into that as well. And a good example of that is a case my learned friend and I did against each other in the Supreme Court called James Bowen and the Commissioner of Police for the Metropolis, which was a case about whether or not the police had owed a duty when settling civil litigation to take into account the reputational interests of the officers who were alleged to have perpetrated assaults on the person who originally sued the police. That was a genuinely novel question, and so the Supreme Court set out the established principles of law and where they pointed, and policy came into that. But those are the only sorts of cases where policy now comes into it.
Can you help me, because you obviously know these cases inside out? This clarification by Robinson and Michael that you don't just whiz to fair, just and reasonable, where you're within the established categories of liability. That's also reflected, isn't there? Because assumption of responsibility goes Smith and Bush, Henderson and Merritt, and through there. And am I right in remembering that a very similar thing is said in Henderson and Merritt by Lord Gough, where he says, if you're satisfied that there is an assumption of responsibility, then fair, just and reasonable has been answered or doesn't need to be said.
I do believe your lordship is right, because I remember that led to a lot of debate in subsequent cases about in which cases did one apply the so-called Caparo test and in which cases did one. And ultimately the position was reached before Robinson that actually, in deciding whether there was an assumption of responsibility, policy factors might come into that. And so it was all rather circular, and I think it was ultimately put that all these different tests were just different ways of arriving at the right answer, and that whichever one you applied should ultimately result in the same answer. But in a sense, Robinson has really made that a lot easier for us all. Many of us didn't pick it up from Michael, but Robinson has spelt it out.
But forgive me if I'm getting confused. Am I right in understanding that really your submissions on the law are, in one sense, very straightforward? There's two categories of liability for public authorities. One is a public authority is treated like anybody else. So if they behave in a way which would incur tortious liability, if they were an individual, and that's where you bring in your illustration, what if Mr. Kendall had gone off, or if another motorist had brought it. And then the second policy is East Suffolk, capital account is, and no liability on a public authority exercising powers unless they make the matter worse.
Yes, it's as simple
And
as
really,
that.
it is as simple as that.
I say it's covered by those two separate branches of the law, is the wrong way of putting it, but those two the areas of law which give rise to those two propositions.
Yeah. Well, I'm sorry to take you back to basics. It may be so basic everybody else was firmly there already, but I think that is the seems.
Well, sometimes we lawyers have a habit of overcomplicating things. But with that in mind, can I turn briefly to the Capital and Counties case, because there is one point that I think is particularly important to draw out of that, and that's this idea that merely because you're the police who attend, or say the fire brigade, that you can expect people will rely on that and rely that you'll carry out some function, because that is in truth a submission of a doctrine of general reliance, which was actually rejected in Capital and Counties in subsequent cases. Capital and Counties, we've already looked at the facts through the Michael judgment, but I should say that if it helps the court, the propositions I draw from this series of cases, starting with Capital Counties, which we're going to look at now, is that firstly, mere attendance by an emergency service, or indeed any other rescuer at an incident, does not create a duty of care. There is no doctrine of general reliance that emergency services or public authorities will perform their duties. The second proposition is, and as point my lordship's just encapsulated, liability will only arise where the rescuer or the emergency service adds to the danger or creates a fresh danger by way of a positive negligent act. Those are the two oppositions I draw from these cases. Turning then to capital and counties, at page 1027,
Just remind me of the tab. Sorry.
oh, I'm so sorry, it is tab
Six.
6, and I should have said it's recorded in the Queen's Bench Division reports for 1997 at page 1004. It was Lord Justice Stuart-Smith gave the judgment of the court, and at paragraph 1027, page 1027 of the report, page 215 of the bundle, at letter B, Mr. Walker, for the plaintiffs in the London Fire Brigade case, submitted that he was entitled to rely on the doctrine of general reliance as giving rise to a duty to exercise statutory powers which have been granted, and or a duty of care to respond to the public's call for help. In the Australian case of Sutherland Shire Council in Hayman, Mason J said, "There will be cases in which the plaintiff's reasonable alliance will arise out of a general dependence on the authority's performance of its function with due care, without the need for contributing conduct on the part of a defendant or action to his detriment on the part of the plaintiff. Reliance or dependence in this sense is in general the product of the grant and exercise of powers designed to prevent or minimise a risk of personal injury or disability, recognised by the legislator of being of such magnitude or complexity that individuals cannot or may not take adequate steps for their own protection. The situation generates on one side, that's the individual, a general expectation that the power will be exercised, and on the other side, the authority, a realisation that there is a general reliance or dependence on its exercise of the power. The control of air traffic, the safety inspection of aircraft, and the fighting of a fire in a building by a fire authority may well be examples of this type of function." Then, as Lord Justice Stuart-Smith said, the principle of general reliance has been applied on a number of occasions in Australia. It was relied upon in Casely Smith and Evans and Sons, but that seems to be a case where a fire authority created the danger. Northern Territory of Australia and Deutsche Club, a case of negligent inspection for the purpose of granting a club licence, and Pyrenees Shire Council and Day. In that case, Brookings J.A. paid some regard to the judgment of Roche, L.J. and Stoven and Wise, which was reversed in the House of Lords. But the doctrine has received little, if any, support in English law. There appears to be no case, except the Anne's case itself, which could be said to be an example of its application. And two of the examples suggested by Mason J have been held not to give rise to a duty of care. In Mark Rich and Bishop Brock Marine Company Limited, a classification society in which a vessel was entered, was held not to be under a duty of care to cargo owners in respect of a negligent inspection of the vessel. And a similar conclusion was reached by the Court of Appeal in Philcox and Civil Aviation Authority. The authority being held under no duty of care to the owner of an aircraft alleged to have been negligently inspected and improperly given a certificate of airworthiness. Further, in a passage of his speech, which is admittedly obiter, but which was apropos Mason J's reference to the principle of Shire Sutherland case, Lord Hoffman, in Stoven's case, said, "The application of the doctrine of general reliance may require some very careful analysis of the role which the expected exercise of the statutory power plays in community behaviour. For example, in one sense, it is true that the fire brigade is there to protect people in situations in which they could not be expected to be able to protect themselves. On the other hand, they can and do protect themselves by insurance against the risk of fire. It's not obvious that there should be a right to compensation from a negligent fire authority, which will ordinarily inure by right of subrogation to an insurance company. The only reason would be to provide a general deterrent against inefficiency, but there must be better ways of doing this than by compensating insurance companies out of public funds. And while premiums no doubt take into account the existence of the fire brigade and the likelihood that it will arrive swiftly upon the scene, it is not clear that they would be very different merely because no compensation was paid in the rare cases in which the fire authority negligently failed to perform its public duty. Although the Plaintiffs' Counsel have criticised Lord Hoffman's reference to the existence of insurance as being an invalid ground for saying it is not fair, just or reasonable to impose a duty of care, we do not think this is what Lord Hoffman is saying in this passage. Rather, he is suggesting that there is not a general expectation that fires will necessarily be extinguished by the fire brigade. There is no doubt a hope that they will, but they may arrive too late to be of practical use, or they may not arrive at all. Instead, for the most part, people rely on insurance for indemnification in case of loss. And then at page 218 of the bundle, letter H, His Lordship said, letter G, counsel for the plaintiffs in the Hampshire case submitted that there are two approaches in principle which lead to the conclusion of liability in their case. First, it was said that although the correct method for deciding whether there is a duty of care at common law is to adopt the approach advocated by Lord Bridge and Caparo, namely foreseeability of damage, existence of a special relationship of proximity, and whether it's fair, just, and reasonable that a duty of care should exist. The direct infliction of foreseeable physical damage is an established category of case where a duty exists. It was argued that Station Officer Mitchell's act of switching off the sprinklers was a positive act of misfeasance, which foreseeably caused the fire to get out of control and spread and caused the loss of blocks B and C and part of block A, which would not otherwise have been affected. It was on this basis that Judge Harvey, QC, found in the plaintiff's favour. The alternative ground upon which it is said that proximity will arise is where someone possessed of a special skill undertakes, irrespective of contract, to apply that skill for the assistance of another person who relies upon such skill, and there's direct and substantial reliance. We turn to the first of these submissions, as between letters C and D. The peculiarity of fire brigades, together with other rescue services such as ambulance or coastal rescue, and protective services such as the police, is that they do not, as a rule, create the danger which causes injury to the plaintiff or loss to his property. For the most part, they act in the context of a danger already created and damage already caused, whether by the forces of nature or the acts of some third party, or even of the plaintiff himself, and whether those acts are criminal, negligent, or non-culpable. But where the rescue protective service itself by negligence creates the danger which caused the plaintiff's injury, there is no doubt in our judgment the plaintiff can recover. There are many examples of this. In Rigby and the Chief Constable of Northamptonshire, the plaintiff's gun shop was at risk from a lunatic. The police came to deal with the situation. They fired a CS canister of gas into the shop, though it caused a high risk of fire, without ensuring that the fire engine which had previously been available was there to put out any fire that resulted. In Knightley and Johns, in the course of traffic control following an accident, 2 police constables were instructed to take a course which involved them riding against the traffic flow round a blind bend, causing a collision in which the plaintiff was injured. In Dorset Yacht and the Home Office, the defendant's prison officers had brought the Borstal boys, who had a known propensity to escape, into the locality where the yachts were moored, and so had created a potential situation of danger for the owners of those yachts, in which they failed to exercise proper supervision over the boys. See per Lord Keith of Kinkle and Hill and Chief Constable of Yorkshire. Similarly, in Alcock and the Chief Constable of South Yorkshire Police, where the question and issue was the liability of the police to those suffering shock as a result of the Hillsborough disaster, there was never any dispute that the police were liable to the primary victims because they had created the danger by incompetent crowd control. These are all cases, however, where a new or different danger has been created, from that which the police were seeking to guard against, except perhaps the Alcott case. A comparable situation would be if on arrival at the scene of a fire, the fire engine was negligently driven into the owner's car parked in the street. But it seems to us that there is no difference in principle if by some positive negligent act the rescuer protective service substantially increases the risk. He is thereby creating a fresh danger, albeit of the same kind or of the same nature, namely fire. The judge held that at the time the sprinklers were turned off, the fire was being contained, but that once they were turned off, it rapidly went out of control, spreading to blocks B and C, which had been deprived of their own sprinkler protection. And I do emphasise what is required is some positive negligent act which increases or creates danger.
And the word positive there, just so that we don't get stuck into acts and omissions again. Really, what is meant is that the negligent conduct, whatever it was, creates a new danger. So if you take your formulation a while ago, your second limb, you express it slightly differently, but it could be said, liability only arises if the rescuer's negligent conduct increases an existing danger or creates a fresh danger.
Yes. That may be a better.
Would you be content with that?
Yes, I would. Because, of course, I'm drawing the contrast with our case, where all the police do is turn up. They don't undertake any positive act which increases any danger at all. It's certainly not any act that's alleged to be negligent. This is not a case where they are said to have, negligently whisked Mr. Kendall off the scene whilst he was in the process of successfully flagging down a vehicle. It's nothing like that. In relation to the, I'm not going to dwell long on the second ground of proximity, which was argued, which was rejected. The point about relationships of reliance and special skill and care and so forth. But at 1034, that was considered, page 1034, page 222 of the bundle, letter G. We turn to the second submission made on behalf of all the plaintiffs that the requisite proximity exists. Involves the concept of assumption of responsibility by the fire brigade, in particular reliance by the owner. As a general rule, a sufficient relationship of proximity will exist when someone possessed of a special skill undertakes to apply that skill for the assistance of another person who relies upon such skill, and there is a direct and substantial reliance by the plaintiff on the defendant's skill. There are many instances of this, and we've looked at some of them already. But it is maybe worth noting in letters C and Barnett and Chelsea and Kensington Hospital Management Committee, Mr. Justice Neild drew a distinction between a casualty department of a hospital that closes its doors and says no patients can be received, in which case he would by inference have held there was no duty of care, and the case before him were 3 watchmen who had taken poison, entered the hospital, and then were given erroneous advice where a duty of care arose. And it's this I refer to in particular. Likewise, a doctor who happened to witness a road accident will very likely go to the assistance of anyone injured, but he is not under any legal obligation to do so, save in certain limited circumstances which were not relevant. And the relationship of doctor and patient does not arise if he volunteers his assistance. His only duty as a matter of law is not to make the victim's condition worse. Moreover, it is clear that no such duty of care exists, even though there may be close physical proximity, simply because one party is a doctor and the other has a medical problem, which may be of interest to both. Now, the reason I draw attention to that is, of course, there may be many situations where members of the public are present when some emergency arises, and some may incidentally have greater skills or experience than others in what to do in those situations. But they too, as the law stands, only come under a duty of care if they make the harm worse or make a fresh danger. And to hold otherwise, it's simply by volunteering and saying, hold on, I can help, on this flight. I'm a doctor. And to hold that that might have deterred someone who might have been a better competent first aider and who might have saved the plaintiff, that that's enough to hold that doctor liable if they were negligent in how they treated the victim of the heart attack or whatever, would simply be to discourage people from coming forward to help. But it's the same point, is that one's looking at this as one has to look at it from the point of view that there's nothing special about the police. The plaintiff at page 1036, letter D, the plaintiff's counsel argued that the provision of section 30, subsection 3 and 2, which confer on the senior fire brigade officer present sole charge and control of firefighting operations, and made it a criminal offence willfully to obstruct or interfere with any member of a fire brigade engaged in firefighting, establish a proximate relationship once responsibility for fighting the fire is taken over by the brigade. That argument has its attraction, particularly on the somewhat extreme facts of the Hampshire case. As Mr. Slater pointed out, the plaintiffs had two systems of firefighting, one very effective in the form of automatic sprinklers, the other the manual firefighting capability of their employees. Station Officer Mitchell rendered the first ineffectual and ordered out of the building the plaintiff's employees who were attempting to attack the fire. But it seems to us that the statute imposes control of operations on the senior officers for the benefit of the public generally, where there may be conflicting interests. By taking such control, that officer is not to be seen as undertaking a voluntary assumption of responsibility to the owner of the premises on fire, whether or not the latter is in fact reliant on it. And then at page 1038, letter E to F, His Lordship concluded, having reviewed a number of cases such as East Suffolk, Kirkham and the Chief Constable of Greater Manchester Police, Welsh and the Chief Constable of Merseyside Police, Osman and Ferguson and Barrett and the Ministry of Defence. They were all examples of cases where the court has considered on the special facts of the case that there is a sufficiently close relationship of proximity to give rise to a duty of care. But we do not think they are anywhere near the circumstances that arise in these appeals. In our judgment, a fire brigade does not enter into a sufficiently proximate relationship with the owner or occupier of premises to come under a duty of care merely by attending at the fire ground and fighting the fire. This is so even though the senior officer actually assumes control of the firefighting operation.
So in modern parlance, that's really shutting off a Headley Burn line of thinking.
Yes. But there would have to be something very special about the facts for it to be a Headley Burn line of thinking.
Headley Burn stroke Dorset yacht.
Yes, because this also, the only reliance that conceivably could be is a general reliance. Well, we assume that when the police turn up, they're going to make the road safe. That's not enough on this authority, first of all, because, as later authorities also confirm, there is no doctrine of general reliance in English law. But secondly, because that's not enough to give rise to an individual relationship, proximity. The claimant does not have a special relationship with the police because it's the same relationship every member of the public would have with the police. So it really is, as my lordship says, shutting that off. And if it were otherwise, if my learned friend was right, that it's enough to create a duty to have a general expectation, that there is a general expectation that emergency services will exercise their statutory powers in a competent way. If that's enough to create a duty, well, that would fly flat in the face of what the Supreme Court have said in Robinson, and Poole about the fact that the police or other agencies have special statutory powers and duties is not enough to result in them having a duty. It would be completely inconsistent with the line of authorities which our Supreme Court as handed down. Well, I noticed the time, but I could deal briefly with OLL and the Coast Guard of that. Well, maybe my lord might think it's not the case to be dealt with so briefly.
Please deal with that.
OLL and the Coast Guard, which is at tab 7 of the bundle.
Was it rightly decided?
It's rightly decided, I'm afraid. I submit. Certainly Lord Toulston seems to have thought so, and his opinion matters more than mine.
Neatly done, if I may say so, Mr. Warnock.
OLL in the Secretary of State is the case which we've really looked at the facts of, where this search and rescue operation was undertaken by the Coast Guard, but others were helping too, including the Royal Navy, and it seems the manager of the home. And misdirections were given, and the head note actually is just worth looking at it. The party got into severe difficulties at sea. A search and rescue operation was undertaken by the Coast Guard, who were later alleged to have failed to respond promptly and to have miscoordinated the rescue attempts of others to the extent that they gave the manager of the challenge centre misplaced assurance about where the party was likely to be, misdirected the lifeboat to search inshore rather than offshore and in the wrong area, misdirected one Royal Navy helicopter and failed to mobilise another until 5 p.m. And at page 899, Council's submissions are summarised just from letter F of the particulars of claim. Paragraphs 4 to 9 of the statement of claim set out a detailed account of the rescue attempts. It's not necessary to rehearse these in full. The factual case is summarised in paragraph 10. It is said that from about 2:40 p.m. or shortly after that, the Coast Guard knew or ought to have realised that the party was missing and overdue, and that at least one of the party was or might be in the sea and parted from their canoe. Soon after 3 p.m, the Coast Guard intervened, telling the manager of the plaintiff not to worry and saying that the Coast Guard would conduct a search limited to a land search. From then, the Coast Guard was in effective control of the search and rescue operation. They made the position of the party worse by taking no steps to launch an appropriate search and rescue operation until about 3:48. They made the position of the party worse by misdirecting the lifeboat to search inshore rather than offshore on the area of Datton Point. They made the position of the party worse by directing a Royal Navy helicopter from an appropriate search to an inappropriate sweep up and down the coastline. They made the position of the party worse by failing to ask the Royal Navy to scramble a second helicopter, although they'd been asked to do so earlier. And at page 904, from letter D, we've already looked at the passage. Mr. Justice May referred to capital and counties and set out the passage we've looked at about the peculiarity of rescue services. And then at page 905, Mr. Justice May said the court then considered whether the fire brigade could be said to have assumed responsibility and held that by taking control of operations, the senior fire officer is not to be seen as undertaking a voluntary assumption of responsibility to the owner of the premises on fire, whether or not the owner in fact relies on the fire brigade. Simply by attending the fire and conducting firefighting operations, the fire brigade do not, save in exceptional circumstances, such as in the first case, create or increase the danger. In conclusion, the court held that the fire brigade does not enter into a sufficiently proximate relationship with the owner or occupier of premises to come under a duty of care merely by attending at the fire ground and fighting the fire. This is so even though the senior officer actually assumes control of the firefighting operations. The court then considered whether it was just, fair and reasonable to impose a duty of care, asking the question whether the fire brigade should have the benefit of immunity as a matter of public policy. The conclusion was that they should not, in cases whereby their own positive action they had created or increased the danger. as where in the first case they had ordered the sprinkler system to be turned off. And the result, duty of care was established in the first case, but not the second. And then at letter H, council recognises, I think, that for those allegations said to be breaches of duty by the Coast Guard, which have no element of positive intervention, he is scarcely able to find material reasons for distinguishing this case from the Capitals and Counties decision, which is binding on me. Indeed, there is no obvious distinction between the fire brigade responding to a fire where lives are at risk and the Coast Guard responding to an emergency at sea. On this basis, the Coast Guard would be under no enforceable private law duty to respond to an emergency call, nor if they do respond would they be liable if their response was negligent, unless their negligence amounted to a positive act which directly caused greater injury than would have occurred if they had not intervened at all. Mr. Stuart-Smith has three submissions. Firstly, accepting that some of the allegations have no element of positive intervention. He submits subparagraphs D and G are allegations that the Coast Guard intervened positively in its coordination of other rescue services and therefore materially increased the risk so as to create fresh danger for the canoeists. These are the allegations that the Coast Guard negligently diverted the plaintiff's manager, that they misdirected the lifeboat and the Royal Navy helicopter, and that they failed to mobilise the second helicopter. Mr. Stuart-Smith suggests that these are to be seen as equivalent to the fire officer ordering the sprinkler system to be turned off. The Coast Guard positively made things worse by removing the potential for other services to save the canoeists earlier. He submits it's not always easy to draw a line between what's to be regarded as an omission and what's a positive act. The court should look at the question at a given moment and ask whether the degree of intervention is such that the Coast Guard's coordination of others may not be intervention positively causing damage. And secondly, he submitted there was an assumption of responsibility. By intervening, they crossed the line dividing between mere omission from positive act. The Coast Guard knew that other searchers would take directions from them, as they in fact did. The class of people to whom the Coast Guard owed the relevant duty were the canoeists, who were known to be by the Coast Guard to be a particular risk. It was a small identifiable class. It was said the Coast Guard were not acting under a statutory scheme. And then relying on, I think, what was probably that may have been the Court of Appeal's decision in Stoven and Wise. I'm not sure about that. Anyway, Mr. Stuart-Smith's submitted duty of care arose from expectation that the Coast Guard would act, an act carefully created by ministerial pronouncements and a common knowledge that the Coast Guard will act when it knows of an emergency at sea. It might whether it was the House of Lords. In my view, this submission strains what Lord Hoffman said in Stoven and Wise beyond breaking point. Lord Hoffman was discussing the judgments in Sutherland Shire Council and Hayman under the heading Particular and General Reliance. He accepted as generating the duty the common law example of a lighthouse authority, which creates in mariners an expectation that its light will warn them of danger. The authority owes a duty not to extinguish the light without giving reasonable notice. But he then said a wider doctrine of general reliance, and that's the passage we looked at in Capital. In the Capital and Counties case, Stuart-Smith LJ referred to the principle of general reliance, and in doing so discussed the passage from Stoven and Wise to which I have referred. He said that the doctrine has received little of any support in English law, and that there appears to be no case except Anne's itself, which could be said to be an example of its application. And then he referred again to Sutherland and the cases not finding favour in English law. And further, in my view, a particular duty derived from a specific expectation publicly induced and relied on that a lighthouse authority will not withdraw an existing light without giving due notice is very different from a general duty on the Coast Guard to conduct any search and rescue operation they may undertake without negligence. And then at H, he said, I consider the Capital and Counties decision is to be applied to the Coast Guard. The remaining question is whether Mr. Stuart-Smith is correct in submitting that the misdirections given by the Coast Guard to other rescue organisations are to be equated with the fire officer negligently ordering the sprinkler system to be turned off. In my judgment, they are not. Mr. Stuart-Smith accepts that if Capital and Counties cases to be applied, no duty of care arises if the Coast Guard misdirect their own rescuing people or equipment, just as there would be no liability if the fire brigade misdirected its own fire engine. In my view, a distinction which would render the Coast Guard potentially liable if they give misdirections to other people which do not result in positive injury directly inflicted is quite artificial. If there were two helicopters, one belonging to the Coast Guard and the other to the Royal Navy, it would be nonsensical if the Coast Guard were liable for the directions given to one but not the other. Nor am I persuaded you can sensibly impose liability by assessing a level of intervention which falls short of intervention results in positive injury directly inflicted. Further, the clear dividing line adopted in the Capital and Counties case, which goes back to a time earlier than the East Suffolk case, is crossed where a defendant directly inflicts physical injury. Directly inflicted physical injury is the first building block of the law of negligence, because unless it is excused, it will always be a component of a breach of duty. Misdirecting other rescuers does not of itself inflict direct physical injury, any more so than misdirecting the Coast Guard's own services. And it's what I say in summary about that case is, in a case where no liability attaches, where the Coast Guard are actually alleged to have positively directed a helicopter which was carrying out an appropriate search to go somewhere and carry out an inappropriate one, and liability does not attach, it is really quite hard to see how there could be liability on the facts of our case, where the police aren't alleged to have given any direction at all to Mr. Kendall. So
I still think, I know this is dangerous, I still think that there is a distinction between misdirecting a lifeboat or a helicopter, which is a third-party agency, which was in the right place, telling them to go somewhere else, which reduced the chances of finding them, to simply not competently directing one's own helicopter.
Well, there certainly is a respectable policy argument as well. Actually,
that's very kind.
And my learned friend indeed refers to an article written by his junior on the pleadings, although not at the moment, Duncan Fairgrieve and I think Mr. Dan Squires, the Constable, where they say it's. But essentially, they don't like the law as it is and say it should be different.
But your point remains.
But my point is, it is the law as it is. And that's, it has been expressly blessed, as it were, in the Michael analysis. And it fits with the Michael analysis, actually. Because in a case where, like this, as your Lordship has described, there isn't actually a rescue in progress which is alleviating the actual danger faced by the people out at sea. It's not like you've come and yanked someone off who's about to pull
It's
them into
more like
a boat.
if, in your earlier example, if another motorist had come and put out his triangle,
Yes.
and the police officers had turned up and said, "Take your triangle down."
Yes.
That seems to me to be anyway.
But I think there is, well, what I submit is there is a distinction perhaps between something which might potentially have alleviated the danger had that intervention not have happened, such as if the Royal Navy helicopter had not been misdirected, it had the potential to find the claimants in this case. There's a difference between that which doesn't actually touch upon the source of danger which the claimant is facing, and a case like the Daily one we're about to look at later, where in fact somebody's actually in the process of doing a rescue and therefore alleviating the danger, actually in fact alleviated, and you stop it. That may be the distinction.
Thank you very much, Mr. Warnock. How much longer have you got to go, do you
I think probably about an hour.
About an hour. Mr. Byrne, perhaps you can let us know then how you are and whether you're able to continue. You don't need to say now, see how you feel afterwards.
Thank you.
2:10.
Compromise.